Liberty Fighters Network.
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 Liberty Fighters Network. Liberty Fighters Network.
Good day, liberators and fellow South Africans. After a very emotional part one, where I've explained the true relationship between myself and Louis Liebenberg, and not as people have fabricated over social media, or I believe they have. I know that Louis has also made videos about me, and I haven't watched any of his videos, and I don't care if he has said something bad against me or something. Well, also what? But I think after today, and after I've made part one, which I ask everyone who watch this video, part two, to first watch part one, and you will then have the full picture of what is going on. You must watch part one from the beginning to the end before watching part two from the beginning to the end, and everything will make sense to you. It's time that the truth must come out. And this is my commitment, my input to ensure that the truth comes out. And if there's anyone who hates Louis Liebenberg or says that we've got money under the table, whatever the case may be, for saying what I'm doing, number one, I haven't spoken or communicated one-to-one with Louis Liebenberg since we parted ways way back 2006, 2017, or thereabouts. I did say that I'm not very good with dates anymore. I'm starting to get Alzheimer's or whatever. So I'm not 100% specific on dates, but it did happen. So for roughly 15 odd years, Louis Liebenberg and I have not spoken to one another one-to-one. We have not seen one-to-one. And as I've explained in part one, that I've tried to communicate through an intermediary called a person called by the name you most of you should know, Mike Bollhuis. I've tried to communicate before for the reasons I've stated, but we haven't come together. So this is the time that I have my opinion on why Tariomix should not follow the tragedy of Well For You. Why this company should not be liquidated. And thanks to Honorable Retired Judge Eberhard Bertelsmann, and you should know that I totally dislike the Judiciary of South Africa and the legal fraternity. I'm not sitting around the same table as they are. The evil of the judiciary, especially in South Africa today, should be rid. We should destroy it, really. It must come to a point where it must be totally reformed, not transformed, reformed. We must break it down until the bottom and rebuild it into a new one that's unique to South Africa and Africa as a continent. But that's a story of another day. So when I read this report specifically of retired Judge Bertelsmann, I just thought, oh no, come on. There's a practice amongst the Blackcoats, the Batman Brigade, that they can twist stories by speaking the truth in one direction, but totally forgetting what is going on the other side. So in our cases as well, when I was accused of contempt of court and the whole charade of the proceedings before the Supreme Court of Appeal, which have turned out to be a total travesty and a total embarrassment to the entire judiciary and the legal fraternity at the end of the day, and still continue to do. But when I read that report, I just thought, you know what, how can, firstly, people, he's retired. So he's not a judge anymore. So if you read his report as the commissioner, and you come to the point whereby you read that he's a retired judge, he's not a judge anymore. He is a retired judge. So it means that he went on pension. So he did not make a judgment. And let me just show you how my opinion of Eberhard Bertelsmann is not very good, because he was the one. Let me show you this. If you don't believe me, let me show you the truth of there you have it. Let me just. I hope. There is the Christian Lawyers Association of South Africa and others, Vice Minister of Health and others, 1998. This was the case that was is used to justify abortions in South Africa. And when you go down here, oh, my good friend Wim Pringove, senior counsel, was sitting on the government side, and then, oh, Eberhard Bertelsmann was for the Christian Lawyers Association. And people, this is the case that is used today to justify abortions in South Africa. If you know me, I'm as a Christian, I don't support abortions. I don't care whether it's for contraceptive or what the hell ever. I believe that abortions are killing children. That's what I believe. So this was the case, but that has never gone on appeal. There's no indication that Eberhard Bertelsmann, it was as if this was concocted, that it had to go this way. A single judge has decided in that case without going on appeal, just like AfriForum and Solidarity also go on to take these strange cases and they fabricate and make it go in a certain direction, and then everyone is upset, or everyone must suddenly believe, like happened in that other case in the Labour Court, where Solidarity has not even taken it on appeal, where it was justified that companies can get rid of their employees who refuse to get vaccinated. So this is a similar case. It was concocted, according to me. Eberhard Bertelsmann, Wim Pringove, everyone were part and parcel of that. And the arguments that have been put in there was pathetic. Eberhard Bertelsmann, sorry, you say that you are a Christian, but the way that you have not pursued and went after this with everything that you've got to stop abortions in South Africa, well, there are sufficient reasons, what we will soon in Liberty Fighters Network prove. Sorry, I'm not on the same page with you. So when I've read your report, I just thought, oh my word, is this a deja vu of pushing a narrative to go in a certain direction? And let me just first start off and show you this, which you have not known, probably. Look at this certificate of appointment. These are the liquidators, the provisional liquidators, that have been appointed, and there is a lady by the name of Nini Mahanyele. And let me show you. This is a deja vu. Diamond. This is an article just shortly after Well For You was liquidated. Liquidator Johan Nel of Ruenel Financial Trust. That's incorrect. It was supposed to be Ranel Trust. Johan Nel. And he was the liquidator, one of 3 liquidators. And now when you go back, who is this Nina Mananyele? Sorry. Let's go to her affidavit, and I will show you Johanna Nini Mananyele. There's a name. And shucks, people, Ranel Trust. This is a deja vu. So the same liquidators that were involved in Well For You are also now the liquidators in Tariomix. So Johan Nel is still with, when you go to their website, and you will see that Johan Nel is one of 3 directors of Ranel Trust. So this lady is just a representative for Ranel Trust. So unfortunately, this is already a red light for me, because they've got the experience from Wealth For You, and I sure golly wolly, I can guarantee you that Johan Nel is sitting there and he knows exactly how he liquidated Wealth For You, and he's definitely guiding his colleague, his fellow director of Ronel Trust, in doing the same. Our focus was always on Advocate Victor, and Advocate Victor, if he is anyway related to Justice, Madam Justice Victor of the Gauteng division in Pretoria of the High Court, then I see further red lights, because I don't trust Victor at all. Justice Victor is one of the captured judges. So if there's some sort of relationship between them, if there is not, sorry, Advocate Victor, but if you're related, I would like to know whether you are related to Justice Madam Justice Victor. So if there's a relationship, I would say red lights. Number 2 for the liquidators. So when I've gone through this report that was given to me, I thought, am I missing something? How is this possible? Just have a look at this. In the report, the 4th report, let me just quickly do that search. The first problem is, according to court papers filed by SARS, Tariomix is indebted to SARS in an approximate amount of 90 million rand. People, if Bertelsmann claim that there is no operations or no income generated by Tariomix, how is it possible that SARS says that they are owed 90 million rand? Aren't you supposed to pay taxes on income that you received through business activities? So who is lying here? How can SARS say on their own version that Tariomix owes them 90 million rand? So that basically implies that there should have been billions of trading from the information that was given. All the 90 million rand is false. So how can you provisionally liquidate a company bound on totally fake figures? Because it's either fake or they are lying that this is a pyramid or a Ponzi scheme, not generating any money. That's the further red light that I've seen. So then I've gone, and because Bertelsmann's report is so, you must just remember that how this Batman Brigade works, that even if you're retired, you keep your status as a judge. Okay, but because you're on retirement, it means that you cannot do judge work anymore. So you're either they believe that you've lost your marbles, or you're just plainly not capable on your old age to do the work that you used to do, and you need to go on retirement. But now how this legal fraternity works is that now this judge on top, even if he's retired, his inputs are so valuable, because when it's presented as a retired judge before another judge, and especially if it might be an acting judge, he is compelled by his oath of brotherhood to follow the belief system of his elder, Justice Bertelsmann. Okay, so now that is a problem. But now let me just go into this infamous report of Bertelsmann that will most probably be utilized with aggression in court as the power, the empowerment to just finally liquidate Tariomix. And let me just go to that report and let me explain it from as far as possible. Sorry, people. There's this important one. Oh, look at this contract, which between look at this. This contract says, it's recorded here. It is specifically recorded that the first party encourages the second party only to participate from surplus capital in the forward sales trade of transaction venture and refrain from investing funds required for daily upkeep and survival. So here, I confirm what Louis has also said on the meetings and for the people that please don't put all your eggs in one basket. He did it in well for you, and here he definitely learned from the mistakes before, and he has specifically recorded it in this straightforward, valid, lawful agreement. Let me just go further, and this will become more bizarre and surprise for those who support the narrative that Louis Liebenberg is apparently a criminal of some sort. Let's go into then arbitration. There's an arbitration clause, so it means any dispute that may arise from the conclusion, interpretation, execution, termination, or otherwise of this agreement shall be determined by arbitration in terms of the Arbitration Act. Any party shall, however, be entitled to obtain urgent or interim relief from a court of law pending the outcome of the arbitration proceedings. How can there be any legal matter before court if there's no indication that the arbitration clause has been effected? You must follow arbitration before you go to court. So how was it possible? I haven't seen the original liquidation application papers, but from this alone I can see that something is not kosher here. Why is there no mention of any arbitration that have been followed? No, in the report, I've seen the other three as well, which are in somewhat similar. And the strange thing about the entire liquidation is that there was no proof of any claim that was there at the beginning of the liquidation, but suddenly through the provisional liquidation, there's suddenly claims. Now, this reminds me of what happened with the national state of disaster for COVID-19 as well. The government there was no disaster at the beginning of the declaration of a national state of disaster. But the measures that were taken throughout to combat and prevent COVID-19 became the disaster. So to justify that there's a disaster. They had to provisionally liquidate, according to me, Tariomix in order to tell the investors that you must claim your money. So obviously, 40,000, 45,000 said, okay, I've got money there, so I want my money back. So it's not that they've claimed it as for the fact that they are creditors of Tariomix. They claimed it because the liquidators asked them that they must submit claims for the money that they've got there. So most of these people most probably don't even know what they have created. Now suddenly it's said that the company is insolvent. But if it wasn't for their claims that have been put in, and if it wasn't for the 90 million rand alleged SARS claim, there would have been sufficient assets to prove that the company was not insolvent. Take away the claims that the liquidators now say there are, and also the 90 million rand, then you only got 750,000 rand allegedly owned to Corey Kluter. And to be frank, if he for any way did the same crap work as he did in Well For You, as I can confirm that he did, how the hell can he, or how does he expect 700, can he justify the 750,000 rand outstanding to him? Can he? I don't know, but well, let's assume that's the only claim against the estate of the company. Then the company is not insolvent. And then, if they say that this is a Ponzi scheme, I need to get to that point. So let me just go to that part. The insolvency inquiry. This is now the insolvency inquiry by the undersigned. Bertelsmann called him the undersigned. Now, the undersigned was appointed as one of 3 commissioners. Now, The others are not even mentioned. What they are, he says, I will show you that he says that he does not know even if they've got an inquiry. So the other two are just oblivious. They are just there. So it appears as if this one report of this one commissioner, a retired judge, who's allegedly still part of the Batman Brigade. I can't see the logic how this one commissioner can determine the fate of 45,000 other people and effectively the entire country. Let me go further into his report so that you can see. I've made markings here. The undersigned has not yet seen any independent confirmation of any actions to rescind the provisional order of winding up of any applications by existing creditors to intervene, but there can be no doubt that a significant change in the litigation concerning the company appears to be afoot. He's got that right. There will be. In the light of these circumstances, the undersigned has been requested by the liquidators to prepare this interim report. So the liquidators, have outlined him only to conduct the inquiry. So the other commissioners are totally excluded. So they've specifically asked him to do that. Yeah. Let's further go on. It must be underlined that the undersigned has presided alone over several days during which evidence regarding the company, its business assets, liabilities, and the activities of its guiding minds has been led. The inquiry is continuing and the undersigned is unaware of any inquiries conducted by his co-commissioners, nor does he have any knowledge of any evidence which may have been led before any co-commissioner. That's what I confirmed. It must also be emphasized that the undersigned has not yet had the opportunity of receiving the evidence of the central figure who guided the company, Mr. Louis Liebenberg, blah, 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 blah. And let me stop there again. How can you have an inquiry without the main suspect or the main witness? Louis Liebenberg is definitely the main witness, so how can you have a complete interim report if you don't even have an inquiry yet with the most important person? Okay, strange. But Eberhard Bertelsmann believed that he could. So let's clap. Give him the credit for that. Then let me go to this is the report if you have not seen it. Then here is the very important. Mr. Liebenberg is no stranger to controversy when it comes to dealing in diamonds. During or about 2005, he launched a scheme not dissimilar to the one under discussion at present through series of companies known as Well For You. This scheme attracted the unwelcome attention of the Reserve Bank, the revenue authorities, and the then CIPRO. There is where I come in. Well For You could never have been a pyramid scheme. Worst case scenario, it was a bad investment that gone wrong in a business who had failed. If you are a shareholder in a company and you pay shares in there, and there are diamond operations, but not as much as you would like it to be in order to get dividends at the end of the day, it does not imply that it was a pyramid scheme. I know that Justice Duplessis referred the matter upon liquidation of Well For You to be investigated as a so-called pyramid scheme to the Director of Public Prosecutions, and for the fact that there are no prosecutions, one can reasonably accept that the Director of Public Prosecutions determined that it was not a Ponzi scheme or a pyramid scheme or a scheme at all. It wasn't a scheme. A business is not a scheme. It's a business. So how they can refer to it as a scheme, I honestly don't know. So there's a major difference, people. Then let me continue further with that. He engaged the services of his then auditor, Dr. Kluter, to advise him and to negotiate on his behalf with the authorities who suspected that the Ponzi scheme was afoot. With the investigation came a substantial tax assessment. Dr. Kluter persuaded the Reserve Bank that the business model was not a Ponzi, which left the tax assessment, which, as Dr. Kluter would have it, Mr. Liebenberg refused to sign the income tax return and after a few weeks informed his advisor that the matter had been resolved at a fraction of the sum which the receiver had claimed. Just how the settlement was reached was never disclosed. This is somewhat poking the hornet's nest, because now a judge, a judge in inverted commas, now makes the assumption that there was some sort of criminal activity involved. How he arrived, while saying that he did not receive the evidence, his main investigation is bound to be upon the media, and he derives his conclusion that it's a Ponzi scheme through the media. Okay. Then let's go further, people. The business conducted through the company consisted of the marketing of so-called packets of diamonds in which members of the public were invited to invest. Okay, he says that was the business of it. But important here, the company and its director prefer to refer to the persons participating in the scheme as participants in a so-called joint venture, and saw to it that every participant in the scheme signed a standard form agreement that referred to the participants in what will be demonstrated to be a Ponzi scheme as a party in a joint venture. A copy of the standard terms agreement are next here to us in lecture. A joint venture is defined. Okay, he defines it like that. I will just show you this and then I will react to it. The essence of the company's business, however, was and is that members of the public were and are apparently still through another Liebenberg company persuaded to participate in the scheme by advancing money to the company as part of a purchase of a portion of a packet of diamonds. These diamonds would allegedly be acquired and sold solely to Mr. Liebenberg, and they would substantial return as was promised of 100 to 300%. I could not see anywhere in the contract that there would have been 100 to 300% profit on it. There's no such thing in the contract. So if people have believed at some stage in time that they would receive 100 to 300%, it would have been, I believe, been said under the auspices that those are the possibilities and not the facts. If you wanted it to be a fact, you should have put it in the contract that those would have been the profits. And or otherwise, if not, then you should never have joined. The contract, as I have read it, is so clear on what the aims of and the purpose of the contract is. And I can't see that the contract would be invalid in any way in the basis of what was agreed on. I find it very difficult to understand. Then let me go further to I want to get to the nice part, where Bertelsmann totally lost it for me. A business model of this nature would unsurprisingly attract the suspicion that it was a sophisticated version of a Ponzi scheme. The so-called joint venture, in which the investors were invited to participate, and none of the useful features of a joint venture or partnership agreement apart from advancing money in the hope of receiving a substantial return. Blah, blah, blah. That is the basis of business. If you want to make profit, then you need to invest it, and there's a possibility of getting profit. But let me get to Dr. Corey Kluter advised that the agreement should be clothed in the scope of a forward sales offtake agreement. But I want to get to the part where he says the standard form agreement, which creates the so-called JV relationship annexed hereto, exhibits none of the principal features of a forward sales of as described in the quotation. In contract law, there's the specific in order to have a valid contract, there's roughly 5 essentialia which need to be present in order to make it a lawful contract. It's for example, you must have the locus standi, you must have the authority to make the agreement. It must be possible to have the results that you want to. It must be lawful. Sorry, I'm just, but there's roughly 5 essentialia. Now, what that means is that a contract doesn't matter whether you call it a shareholder, whatever you call it by the name. What you've agreed in paragraph of paragraph, that is the key. That constitutes the contract. So whatever you call it or what it should have been that, but when it turns out to be something else that you have concluded and you've agreed on the outcome thereof, then that's a total valid contract. You can call a contract whatever you want. Whatever you want. And if you need to interpret it on what was agreed, not what was assumed or what you as the commissioner think that it should have been or is. That's the commissioner is not a party to the agreement. So what is important, what the agreement was between Tariomix or any other linked company and the thousands of investors or the people who put money into this. That's all that's relevant. Then this is, as the scheme expanded, involving thousands of South Africans and many millions of investor funds, the fiscal authorities, the banks, and the national prosecuting authority took note of the vast sums that were invested and dealt with by the company and its guided minds virtually exclusively in cash. It's the best thing to do business in cash. But the fact that so vast amount of cash transactions took place alerted the South African Reserve Bank and the authorities in the Fiscal and National Prosecuting Authority. That's our problem today. We are too much linked to digits. Less than probably 5% of all transactions, currency transactions, are these days affected by currency or physical money that is handed out, and money has become digits on a computer system. It has lost the total value it's supposed to have, and only if you want value in money, you need to have it in currency, or that is what this banking system claims us to be, which is something for another discussion. But there's nothing wrong with cash transactions, nothing wrong. It's actually encouraged in order to protect, because the more currency is being printed, that's how it's supposed to work, the more value the currency should have, because then there's a demand for the currency of rand, and that's a positive thing. That's a heavy positive thing. And the business model was advertised as a joint venture with the option to intention of escaping the strictures of the prohibition of taking deposits without a banking license in terms of the Banks Act. Oh my word. There's absolutely no indication whatsoever that the business venture was to be a bank. You must have the intention of being a bank in order to claim that you have not been registered and now you're going to be prosecuted because you are a bank. There is no indication whatsoever that the work of or the operation of Tariomix was ever one of to be a bank. I don't think that any one of the 45,000 odd investors have ever thought for 1 minute that they are putting their money into a purported bank. I can't see it. Sorry. There's absolutely no evidence whatsoever that the business of the company was ever to be a bank. Never. Then otherwise, and then FNB said, their reputational risk, the scheme presented. It's very much important to hear or to focus on Bertelsmann's use of suddenly calling the company a scheme. He's got a reason for that, and I'm going to show you now why he's saying so. So devious. But in any event, now, banks are entitled to terminate a business relationship with a client suspected to be involved in unlawful activities. Okay. The large turnover of cash attracted the Commissioner for the South African Revenue Services, and the undersigned has not had sight of the papers filed in the attached application, has only taken note of one or two newspaper reports indicating that the application itself may have been technically deficient, leading to the conclusion that there was no proof of the existence of a Ponzi scheme. Well, the Bertelsmann again confirmed that he sought his evidence in newspapers. Oh my word! I'm so flabbergasted by this. It gets more bizarre by the paragraph. Let me go in there further. But I would like to get to that. The Ponzi scheme. A Ponzi scheme is an unlawful enterprise prohibited by the Consumer Protection Act 68 of 2008. Amounts to a fraud in terms of the common law and is conducted in contravention of Section 11 of the Banks Act. Now, come on, Eberhard. You want to let the people know that this is a Ponzi scheme. Let's go to Section 43(2)(b) of the Consumer Protection Act. There it is. Permit and related schemes. Now, when you read this, a person must not directly or indirectly promote or knowingly join, enter, or participate in a pyramid scheme. Okay, let's get the facts together for you guys who don't know the law. So that effectively puts all 45,000 of the investors on the pedestal that they have participated, possibly knowingly, in a pyramid scheme. So all the information that have been presented to them, the contracts that they have signed, they had the intention of participating in a pyramid scheme. That is what a pyramid scheme is supposed to be by law. But however, let's see further what is a pyramid scheme in the law that Bertelsmann say you need to look at. And let's further read it. It's referred to subsection 4. This is a pyramid scheme. An arrangement, agreement, practice, or scheme is a pyramid scheme if participants in the scheme receive compensation derived primarily from their respective recruitment of other persons as participants rather than from the sale of any goods or services, or the emphasis in the promotion of the scheme indicates an arrangement or practice contemplated in paragraph. Hey, oh my soul. Eberhard Bertelsmann, you have not told the actual investors who are now the predominant creditors the actual definition of what a pyramid scheme is. And the fact that you are saying that it's a pyramid scheme, knowing well that nowhere, knowing that contract, is there stipulation of whatsoever kind that the people must invite someone else to participate in the scheme. What a pyramid scheme or a Ponzi scheme. A Ponzi scheme is also different than a pyramid scheme. A Ponzi scheme is where there was once this Australian company in South Africa who you've paid, I think, 14,000 Rand. And then you invite someone else to also deposit 14,000 Rand. And then you get a 2,000 Rand or a 5,000 Rand from that amount. And then from that amount, people who join behind you in the network, they also receiving part of that great amount than you are, and so forth, so forth. So those who joined first got a lot of money, and then those who joined later on received nothing. That is a scheme, referral, for both a Ponzi as well as a pyramid scheme. A pyramid scheme is based on something that you purchase at like almost although Golden Products, for example, is a network system, you physically get value. A pyramid scheme is more that you get something, but there's no value in it. But it's a referral system. Nowhere in the contract is there a referral system. Tariomix is not either Ponzi scheme, neither a Ponzi scheme nor a pyramid scheme whatsoever in terms of the Consumer Protection Act Bertelsmann referred to. That's wrong. Bertelsmann, you have lost everything, all the respect that I might have had for you left. I've lost it for you. I think you need to retire and stay in the retirement village. I don't want to even go further into this. I've spent a lot of time discussing it. I think let me say what there is clearly a narrative to target Louis Liebenberg. Now, I always say that that the devil is always straightforward. You must just, and he always tells you how he's going to steal your soul. He tells you in great detail how he's going to do it. But unfortunately, us people have been brought up with the idea that Satan is not in control and he always speaks lies. That's not the fact. The fact that we are programmed and taught to do that, to disregard what the devil says. The devil speaks the truth. And this is on paper. They are saying you must go and have a look at what the Consumer Protection Act says. But in the same way that when you act, you believe him. You believe him in that sense, but you don't go, or you don't go and what he actually says. He basically said that it's not a Ponzi scheme. He also said and confirmed that it's not the pyramid scheme that people think it is. And also, very importantly, before I forget, I've referred to the contract having an arbitration clause in. Arbitration had to have been followed before any other. And then the Consumer Protection Act says that it's the responsibility. Let me show you this in the Consumer Protection Act. I've marked it. The enforcement, yeah. The Commission is responsible to enforce this act by promoting informal resolution and receiving complaints concerning alleged prohibited conduct or offences. So what the Act says is that if there is a prohibited action, whatever, then they have got the task to investigate it. You must lay a complaint. So what should have happened was that 45,000, or at least a substantial number of them, should have gone to the Commission first, to the Consumer Protection Commission, and lay a complaint against Tariomix for allegedly running a pyramid scheme. And then they are going to investigate it. They've got so substantial powers to investigate this matter. And eventually, at the end of the day, they will determine whether it's a Ponzi scheme or a pyramid scheme. And if they determine on their expertise, their investigations properly, that it's a Ponzi scheme, a pyramid scheme, then there's enforcement. Let me go to that point of the enforcement. They've got so substantial powers, compliance notices, and if there is objection to notices, the summons. And what I want to show you specifically, you can go to court, but when you limitations of bringing actions, sorry, I just want to come to the point where, very importantly, sorry, I beg your pardon. Okay, that's it. Sorry, people. I want to show you where it's specifically indicated in the Act that when you claim that a contract is invalid, you must physically file a notice, a certificate with your claim that it was before the tribunal and it was declared as sorry people, I can't find that part now, but it comes to the point that never once the whole entire claim against Tariomix is based on the invalidity of the contract. At no stage has the court declared the contract to be invalid. At no stage has the tribunal or the Consumer Commission declared it as invalid. At no time when a claim was laid, a liquidation is a claim, it also says that you were compelled to have indicated in a certificate that that contract you are basing your claim on has been declared as invalid on a prohibited ground. Nowhere has that happened. No arbitration has been effected. According to me, from the knowledge I've got in the legal system, and it's extensive, this provisional liquidation can be ended. Number one, by attacking the fact that the whole claim is bound on or based on an agreement that has not been investigated to be an alleged pyramid scheme by the Consumer Commission. Secondly, there has not been an arbitration at all, although you could have asked for urgent interim relief, but then the arbitration should have been effected in terms of the contract. Thirdly, you had to have asked the Consumer Commission to have intervened in this matter as well. They should have done the investigation work and not a retired judge. They should have done that before the liquidation even started. And then the whole thing. Nowhere ever has it been stated anywhere that there was a direct effort to approach and get the input from the investors. 45,000 people are just hopping along with a few people have initiated this, and they're saying that this is a Ponzi scheme and a pyramid scheme and whatever. But the actual bigger group of investors, they are just paddling along because they think they must. It's not that they are informed like I'm doing now to say that people, you are being misled. Whoever is telling you that this is a Ponzi scheme, that this is a pyramid scheme, or there's no operations. Number one, there cannot be no operations because then there should not be a 90 million rand claim from the South African Revenue Services because you can only claim tax if there have been operations and income for the company. So that one flies out of the window. Secondly, when it comes to a Ponzi scheme, pyramid scheme, the Consumer Commission had to have been approached first before liquidation started. That's a big problem. There should have been arbitration. There's no indication of arbitration or that any claim has been, a judgment has been granted against the company by any one of these investors who have successfully claimed their money by way of a judgment. There's no such thing. It's only, the only claims that came in that's legitimate were the claims because the liquidators asked you to put in a claim. You have been misled by the liquidators, and I've shown you that one of those liquidators are the same as the ones who did the well for you. So based on this information, there's so many. Liberty Fighters Network, have committed themselves to intervene as an amicus curiae in this matter, on the basis that the investors' rights have not been respected at all. There's no meeting that have been held, no informative meeting of what the implications are. They simply don't know. They are now creditors without them knowing that the fact that they are creditors, there's now leverage for those who want the company to fail, to finally liquidate the company. And people, talk to me. I will tell you the losses the people have suffered in well for you, and unfortunately, you are heading that way if you also continue to support this. You are part and parcel of breaking down this company, and this company cannot be liquidated for the fact that this is the first company of its size and its form, which is a direct threat to the monopoly of the Oppenheimers and the De Beers and the mining moguls out there. And they are the Stellenbosch mafia. They are the agents of the British Crown for ages now already, to steal the wealth of our people. It's time to break it. We must, through this, by our encouragement to make Tariomix a success, we will directly tell the British Crown, King Charles, to bugger off and to eventually please return the Cullinan diamond back to South Africa. It has been stolen by the double agent Jan Smuts and Louis Botha, and have been given to you without the permission of the people of South Africa. So we want it back. You don't use the illumination of that diamond in your crown as your way to manipulate us and the African continent further. That's why Tariomix must be saved. Liberty Fighters Network will commit itself to do anything possible under their control to make this happen. It's not in your best interest as the investors or the partners whatsoever to allow that this company be liquidated. I repeat, I don't want to suddenly say, okay, Louis Liebenberg, please give me money or us money. I don't want it. Just like I've told Jacob Zuma that I don't want 1 cent from him, from our representation for him. The same way, I'm not expecting Louis Liebenberg to put in money into us. I'm not expecting that. And frankly, if I know that he is going to send it, I'll tell you that, Louis is going to send. So you will be 100% aware of that fact. But we are not doing it because we want something. We have survived a lot of battles with the government, the judiciary, and the Schellenbosch mafia. We can survive. But this is important. I see this as the leverage to make or to get the power of the mineral wealth of this country into the hands for the first time of the people. I think Tariomix has got the potential of doing it. It will become our company, the people's company, to fight the Schellenbosch mafia. People, I think if there's any questions, please leave your comments down. Please remember to subscribe, and we into this. If you've got issues with the fact what we are doing now, please let me know. I will deal with it openly in public, and let's fight this fight together. Godspeed until the next time.
Liberty Fighters Network.
Liberty Fighters Network.
Liberty Fighters Network.
Liberty Fighters Network.